Hello friends, how are you? Today I am going to discuss an important topic regarding the child custody and visitation right. As we know that for the welfare and upbringing of child, the father or mother or both plays an important role, because without them it is not possible that the welfare or the upbringing of the concerned child could be assumed. And that's why certain protocols had been given under the legal position so that the rights of the concerned child along with the rights of concerned parents could be secured. Among these rights, the one of the most important rights to have the custody or to have the visitation concerning the ward or the child. Sometime while doing the order, court inter alia direct the father or the mother to meet with the concerned child at the court premises. But in the court premises, it is not possible to bestow love and affection on the child, and that's why we are not in a position to exercise our right in a complete manner. I am totally impressed by the doctrine which is known as ubi jus ibi remedium, which says when there is a right, there is a remedy. But if the remedy is going to be fruitless, then there is no need to give such remedy, specifically concerning the child visitation or the custody. So in that scenario, I am going to discuss the recent legal judgment of the Hon'ble Supreme Court, in which you will get how the rights of the father has been recognized and inter alia the order has been modified just for the recognition and the proper upbringing and welfare of child. So decision is quite important, and after this judgment I will give you some tips if you are having the same issue, then how to submit your case and how you could get such modification easily from the court of law. So video is quite important concerning your right. Keep a pen or pencil with a copy with you so that the important points could be noted down by you and you could easily enforce your rights before the concerned court of law. So let's move on the screen. As you are observing or witnessing, the judgment has been pronounced by Hon'ble Supreme Court of India in SLP Civil number 2437/2023. In that case, the impugned judgment of Honorable Kerala High Court that is passed on 10th of Jan 2023 has been challenged. So we have to see what was the original order and what changes has been done by the Hon'ble Supreme Court in that order. The concerned parties Adarsh means the husband has moved before the Hon'ble Supreme Court and the wife is the respondent, and the wife name is Avasti. In that case, the Honorable Family Court had passed an order by which it has granted the visitation rights of child to the petitioner father and allowed him to meet between 11 a.m. to 4 p.m. on Sundays in the court premises. So that is first part of the order. The High Court did not, however, interfere with the said order. It is in that light the petitioner father is before us. It is a matter of present nature. It is needless to mention, as rightly observed by the High Court, the welfare of child is also to be kept in the view by the court. So the key point is that in part number 2, the welfare of child is quite important. The court specified that at this stage we find that the repeated visitation rights in the court premises would also not be in the interest of child. That is very important. Repeated visitation rights in the court premises is also not in the interest of child, as the environment during which the visitation rights are exercised would also be the matter. So in part number 3, it is quite clear that the visitation should be given. Number 1, it should be immediate, but if the order is made that the child is allowed to be meet in the court premises, in that scenario the environment can also affect the potency of order along with the visitation rights to be exercised. Okay. So therefore at this stage the court specified that we see no reason to dispose of instant petition, but we direct that the visitation rights as granted by the family court shall stand altered. It means it is modified, whereby the interim custody of child shall be made over to the petitioner father by the petitioner mother at the entrance of RP Mall, Kerala at 11 a.m. on Sundays, and the petitioner father may take the child to the said mall and exercise the visitation rights till 2 p.m. of the same day. After that, the custody of child shall be made over to the respondent mother at the same spot, means the entrance of mall where the child was, made over to the concerned petitioner father at 2 p.m. The said arrangement shall continue on Sundays as has been ordered by the family court, and a further consideration would thereafter be made by this court. and later on this matter has been listed on 31st of October 2023. Okay now? So by this order we could conclude the following 4 things. Number 1, for the welfare and upbringing of child, the company of father is sine qua non. It means it is necessary. Number 2, this right should be provided immediately. Number 3, if the court made the order that the child should meet with the father in the court premises, it is totally wrong, because the environment also affects the manner in which the right is to be exercised. And number 4, whenever the order is made, it is to be implemented, and further modification or alteration in such orders are possible. And if the same court, means the trial court, has passed an order which is going to prejudice you, in that scenario, in light of that judgment, as per the protocol of order 47 of CPC. So this is your basic right, because if the law is with you and you knows about your rights, in that scenario you could easily exercise these rights. So friends, it is an important update, and if any update further comes in that judgment, I will definitely update you. See you in the next video. Till then, Jai Hind, Jai Bharat.